Hi there. I'm Sandy Thomson, the host of this show, which is called Life Ahead. And I invite you to be a part of our show by calling with any questions that you might have. It's a legal show tonight, so perhaps you have some legal questions. Our guest this evening, many of you will know if you watch us regularly, Bryan Nugen. Bryan, welcome back.
Thank you, Sandy. Thanks for having me. I appreciate it.
Always good to have you here.
Thank you.
And I'll tell you right now, if you have any questions for Bryan, you might want to get on the phone as quickly as possible, because we always get a lot of phone calls when Bryan is here. And Bryan, one of the things I think is very interesting is that for our topic this evening, we're going to do like a definition. We're doing a dictionary of,
All right.
of legal terms, and we're
I'm
going
ready.
to, because Bryan's been on many times, and in other topics we've had here on Life Ahead, we've used a lot of legal terminology, and we want to kind of go over all of that again and remind you what the definitions are and maybe what kind of circumstances or situations that might be used for. Is that okay?
I'm ready. Whenever whatever questions you've got, I'm ready to go.
Okay, let's start by talking about what does it mean to be in elder law and estate planning. I see under the title of your name it will say elder law. What does that mean?
So there's elder law and there's estate planning. So when we think about estate planning, I think of I'm planning for what happens when I die. Where do my assets go? I've identified who should receive what. Am I going through probate? Am I avoiding probate? When I think of elder law is much more robust. So elder law, not only does it engage in estate planning and transferring assets at the time of your passing, it's protecting assets during your lifetime, making yourself available for benefits that may be out there through programs like the Veterans Administration, Medicaid, etc. So not only is it planning for asset transfer at the time of your passing, if we're avoiding probate or going through probate, it's protecting assets during your lifetime and securing benefits to provide care for you as you age, or if you're a person with special needs. We're looking for public benefits to provide for that. So every elder law attorney does estate planning, but every estate planning attorney does not do elder law.
Oh, that's a good way to...
Yep, they're two very distinct and unique areas, and you need to be aware of them and make sure that if you're looking for protecting your assets as you age, if you're looking at possibly receiving benefits to provide care in your home or an assisted living facility, a nursing home, memory care unit, that you're availing yourself of a knowledge of an elder law attorney to make sure that you have all of your protections in place and your instruments in place, and that you're able to get those benefits, protect your assets, and then eventually also pass your wealth at the time that of your demise, of your death.
You use the word instruments. What does that mean when we're talking about legal terms?
So an instrument would be anything in writing that you're signing, anything the attorney may be preparing on your behalf.
I mean your will, a
could
trust,
be wills,
anything.
could be trusts.
Those are instruments.
Instruments, yep.
Okay.
Could be wills, trusts, powers of attorney, healthcare representative designations, HIPAA waiver forms, any of the documents, any of those instruments that the attorney is preparing on your behalf to get accomplished what it is that you want to get accomplished.
Well, all right, let's talk about some of those. What is living will, for example?
So a living will, when we think of a living will, it has nothing to do with a last will and testament. A living will is, do I have the will to live if the effort to sustain my life is futile? So if I'm actively passing, are you wanting to receive artificial hydration? Are you wanting to receive artificial nutrition? Are you wanting to be kept alive in a persistent vegetative state? It's not a DNR, a do not resuscitate order. A living will is a unique, distinct instrument from that DNR, and what it's saying is the doctor's done everything that he or she is able to do. There's nothing more that they can do. At that point, do you want to be maintained with artificial hydration nutrition, or you're saying, it's okay to let me go. The doctor's done everything that he or she could possibly do. You've received that instruction, and you're saying, it's okay, loved ones, to let me go. What I do like to point out about those living wills, Sandy, is that if you have appointed someone to be your healthcare representative, they can say, I'm not quite ready to let you go yet. I'm going to wait a day or 2 days to see how you're doing, in my own mind, to make sure that you really are actively passing and there's nothing more that can be done. We don't use independent living wills as much as we did. Now we can combine those with our healthcare representative designations. But historically, that was always the toughest thing that I saw people having to sign, because they really had to think about, gosh, if the effort to sustain my life is futile, am I okay saying you don't need to keep me alive? What I encourage my clients to do not only is to sign those living wills or have that living will language put in their healthcare representative designation, but also to discuss with loved ones, what do you want to have done if you are in that situation, if you're actively passing? And the reason I encourage folks to have that conversation with their loved ones is in the heat of the moment, right? When you're stressed out and maybe you haven't seen mom as often as you should have, or dad as often as you should have because your life is busy, you want to make sure that the parent is saying to you, it's okay in that instance. I don't want to be kept alive in a vegetative state. So I'm hoping that some of the guilt will be relieved at the time that someone's needing to make the decision about whether or not to sustain your life.
I know that when you're doing a living will, as I recall, because it's been some time ago that I did my bit, you have several categories that you can choose.
So yeah, in Indiana, at least, the state statute has a format of a living will, and within that living will there are three categories. One is I want to be kept alive, I'm paraphrasing.
Okay.
The first category is I want to be kept alive in a persistent vegetative state. The second category is I don't want to be kept alive in a persistent vegetative state. I don't want artificial hydration and nutrition. Just let me go. And the third option would be I intentionally make no decision. I'm allowing somebody else, my healthcare representative, to make the decision for me. But I would really encourage you, if you're able to do it and you're signing a true living will, make option one or two. Yes, I want to be kept alive in a vegetative state, or no, I don't. When you're passing that on to your loved ones, gosh, that's putting a lot of pressure on them. But that does go back to the earlier point that I made, though. Have a discussion with your loved ones when you're not ill, so that they know what you want, and you're relieving guilt at the time when they're needing to make that decision for you.
I understand. And again, if you love your family and love your loved ones, give them a break and
Sure.
you make the decision for them, whichever you choose.
Of course.
Okay, we have a phone call already, and this is coming in from James. Thank you, James, by the way, for watching Life Ahead here. And he says, if I'm actively passing, but I have no one to represent me, who makes my health care decisions? That's a good question, because I imagine it happens a lot.
It does happen. So if you have not taken that affirmative step to appoint someone to make decisions on your behalf, James, if you're actively passing, if you have health concerns, right, you have a dementia, cognitive impairment, it's possible that a guardian would be appointed on your behalf.
By whom?
Well, the hospital may in fact need to find someone.
Okay.
Need to reach out for someone to be appointed. If you truly have no one, there are folks that volunteer to be guardians for other individuals, and bless them, because it's a tough situation to be put in.
Sure.
But the court would appoint someone to make decisions on your behalf if no one else is there to make decisions for you.
So the judge actually does?
The judge does. So what happens is a guardianship petition is filed, and then someone called a guardian ad litem is appointed to, in essence, represent you and advocate for you, James. So the guardian ad litem would make a recommendation to the court. Yes, a guardianship does need to be established. Yes, this person is appropriate to be a guardian for, in this instance, James. And then that guardian of the person would be able to make healthcare decisions for, in this instance, again, James.
Well, all right, you said that the hospital may step in and assist with that. Are they the ones that would search for a guardian and then prepare the legal documentation for the judge?
This is in an instance where someone has nobody that they've appointed.
Okay.
I assume that there is no family. Now, by state statute, there's an order of priority of who would be able to serve as guardian for someone.
Okay.
It doesn't mean that it's a shoo-in, or you're automatically a guardian if you're a spouse, because you're not. You're not automatically a guardian if you're a child. You're not. But there are categories of folks that the court may consider appointing to be the guardian of someone if they truly have no one around them. So the hospital, their social workers, may be reaching out to organizations that have lists of those folks that may be willing to serve as guardians for individuals that don't have anybody.
Okay.
Yep.
All right. Well, I hope you all have somebody.
Yep.
I hope you do.
And it does happen when folks don't, and
Yeah.
it's tough. So they don't have that opportunity, as I was saying earlier, to say, if I'm in this situation, this is what I want to have done. They haven't had that person to have that discussion with. And it is hard.
Oh,
It's
then
tough.
that leaves the person who may or may not even know them very well
Yep.
in the position of having to
Sure.
make decisions.
Yep, I've served in that capacity for folks that didn't have anybody, and it is the responsibility. I feel a great sense of responsibility for them, and I want to make sure I'm doing an appropriate job for them. And so the person that's serving, we hope that they would have that same attitude and be very respectful of the individual where they are and making sure that they're getting the best care possible, medical care and financial care as well.
Got it.
Yep.
Okay. All right. Some other terminology that you use often when we're talking about estate planning or writing wills: durable power of attorney.
Right.
And healthcare representative. I'm going to put those two together because you often do them together.
So I don't like to do them together. What I found is that folks will, for example, say, gosh, I have one child that is amazing with money. They're on it. They're super organized. They're going to make sure all my bills are paid and invest my money wisely. But they could never make the decision about what health care I should receive. So I'm going to opt for somebody else to be serving as my health care representative. So the power of attorney, it's durable, meaning that if you become incompetent at some point, it's still in effect. In Indiana, that law changed, and this is a random fact, 1991, I think it was. We didn't have durable power of attorneys at the time, and if somebody were to become incompetent, the POA would no longer be effective. So we want to use the language that it's durable in nature so that if you're incompetent, it's still in effect. The power of attorney for finances allows the individual that you've appointed, your agent, their title is attorney in fact. Oftentimes we'll hear someone say, I'm their power of attorney. You're actually not their power of attorney. The instrument, the document, is actually the power of attorney. The person that's serving on behalf of the individual is the attorney in fact, or the agent. So that attorney in fact can do everything that the person that appointed them can do in writing. There are springing and non-springing durable powers of attorney. So
Say that again. What kind?
Springing, like a spring.
Okay.
And non-springing. Springing means if I am incompetent, then it's effective. Non-springing is it's in effect immediately.
Yeah.
I really am not a fan of springing powers of attorney, and my rationale is that if you are concerned that the person would take advantage of their appointment and access your money and use your money in a way that you wouldn't like, if you think that they would do that while you're competent, my gosh, they certainly would be doing that if there was a point in time where you were incompetent. So I will get that question. I'm sure other elder law attorneys get that question as well. I don't want them to be able to use this now. I'm afraid what they're going to do. If you're afraid of what they're going to do, they're not the person to appoint. Appoint somebody that would be very consistent and respect the position that you've provided to them. And then you ask about the healthcare representative designation.
Yeah.
So healthcare representative designation, So healthcare representative designation permits somebody else to make decisions about your person, about your healthcare, if you are no longer able to do so. So this is contrasted with that power of attorney. The power of attorney is in effect immediately, typically, but the healthcare representative designation is only in effect at such time as you are incompetent or incapacitated. I was mentioning a few minutes ago in relationship to your question about living wills, we now can combine that living will language inside our healthcare representative designations, and that's regularly happening now. So we don't see as many standalone living wills as we once did because of the change of law in Indiana.
What does that mean when you said
It's all in one
within
instrument.
the living
So
will?
within that healthcare representative designation,
representative,
we would
okay.
say things like, if the efforts to sustain my life is futile, please, you don't need to keep me alive with artificial hydration nutrition. In that same document, we may also have language that says, I do want to be an organ donor. I'm letting my healthcare representative designee know it's okay to donate my organs if they can be used. But that healthcare representative designation, that power of attorney, are essential documents. Everyone needs those. To James' question earlier in the broadcast, he was saying, what if I don't have anybody? So there are times when we don't have someone appointed because people just didn't get around to it. Even when they're ill or they're facing struggles, I still see folks that don't have those things in place. We want those to be in place. Without it, I have to go to court. I have to request a guardianship. I have to do a full financial disclosure to the court. I have to have an ongoing accounting that I provide to the court. My gosh, if you're able to appoint folks in advance to make financial decisions for you, healthcare decisions for you, so if there comes a point in time where your health goes down, you become incompetent, incapacitated, cognitively impaired, we really want those folks to be appointed so we don't have to go through that guardianship process.
Okay, kind of a weird question, but maybe some of you are thinking the same thing. You've used the word competent and incompetent.
Yeah.
Who decides when you're incompetent?
Yeah, so normally within the instruments that we've prepared, we're designating who it is that makes that decision. Ultimately,
okay.
would be your primary care physician would make that decision. Sometimes you'll see in those documents, it will say that the person that you've appointed could say, I believe that you're incompetent. And then the person that signed the instrument would need to be able to say, that's not correct, I'm still competent. And the doctor then could make the decision about whether or not the person is or is not competent. So
are we talking mental or physical or both?
Mental.
Mental.
Yeah.
All right.
Physical and we wouldn't even say that.
Yeah, we wouldn't, would we?
A physical impairment does not make one incompetent. A physical impairment is simply a physical impairment.
Yeah.
So being physically unable to ambulate, to move, does not alone make one incompetent.
Yeah.
Incapacitated, I've had a car accident, I'm in the hospital, I'm in a coma. Right, it's incapacitated. Incompetent is I come out of the coma, but I have something called a TBI, traumatic brain injury, and I can't think clearly. I'm not who I once was.
Or dementia.
So dementia,
sort of thing?
Dementia's giant category.
I know it
and
is.
underneath that, and underneath the category of dementia, we have the most widely diagnosed type of dementia is Alzheimer's. Sure. Then we have Lewy body, we have frontotemporal, Pick's disease, Parkinson's dementia, any number of different types of dementias. But yes, so you bring up an interesting point. Having a diagnosis of a dementia in and of itself does not mean that you're incompetent. So I can have a diagnosis of dementia, but I could still understand who I am. I can still understand, there's a phrase we use called the object of my bounty, like who's going to be getting my money. You can understand who it is that's going to be signing on your behalf, making healthcare decisions on your behalf. The court wants you to be in charge of your own destiny. So despite a dementia diagnosis, that alone does not mean that you're incompetent. In the moment when you're signing that instrument, do you understand what it says? Do you understand who it is that you're appointing? Do you know them? Generally, do you understand the value of assets and what it is that you're putting into place? So again, a diagnosis of dementia alone, sometimes I'll have people say, oh, they can't sign, they have dementia. Well, I don't know that's true.
It may be a very early on diagnosis.
That's right.
That doesn't really affect
so we could have
decisions.
You and I today could have Alzheimer's, and we don't know it. The disease is taking place, but we don't see the symptoms yet. The symptoms of the disease are I am unable to remember certain things. I know I'm supposed to put this cup somewhere, but instead of putting it in the cupboard, I put it in the garage with my tools. Right? Now we're seeing symptoms of the disease that it's displaying itself in a certain way.
Often some of the early signals, loss of speech, for example, you talked about your cup.
Yeah.
Maybe you can't remember the word for
exactly
it.
Right. You said, this holding my water. What is that now? Oh,
yeah.
Right.
Yeah.
So it's common for us to not to be able to, what is their name? What is their name? That's common.
Oh, good, because I do that.
We all do that. So 2 minutes later you say, oh yeah, that's Sandy. I know Sandy.
Yeah.
But the person that has a dementia, may never come back to them. Yeah. So there are times when we all have mild cognitive impairment. That's a normal part of aging. Dementia is not a normal part of aging.
Okay, we have another phone call for you, Bryan. This from Deb, and she says, when someone dies, does it go to probate? If not when they die, then when?
So thanks, Deb, for asking the question. Let's talk first about probate. So probate is estate administration. That generally means I have my will. If I have a will, I go to court, I open up an estate, I advertise in the newspaper that the person has passed away. Anybody that has a claim, you're welcome to file a claim in the estate. If I don't have a will, we go through something called intestate succession. So last will and testament, I have a will. Yeah. Intestate means I don't have a will. So when someone dies, does it go to probate? If you haven't taken steps to avoid probate, and when I say that, I mean you haven't written a trust, you haven't done beneficiary designations, you haven't done those things. If you have an asset that doesn't have a beneficiary on it through a trust or a beneficiary designation, then yes, the only way to transfer at the time of your passing, with a few exceptions, we would go through probate, go through that estate administration. In Indiana, it's very easy to transfer vehicles upon your death. You could take a death certificate to the BMV and easily transfer a vehicle. So in that instance, the vehicle itself doesn't need to go through probate. So there are some exceptions like that, but generally, yes, Deb, everything does go through probate. Then you say in your question, if not when they die, when? Yes, you would not be going through probate. You wouldn't be going through estate administration during someone's lifetime. That would only happen at the time of their having passed.
Is it usually pretty early on after someone passes, or going to be months or a year?
To be honest, to be honest with you, there are certain timelines that if you don't open an estate within, unsecured debts may be forgiven. So for example, if I have a credit card debt, and I didn't open an estate for, I'm only speaking about Indiana law right now. If you didn't open an estate within 9 months and there's unsecured debt, those unsecured debts are forgiven. They couldn't be pursued.
Oh.
So sometimes we wait to open an estate, but you could open an estate at any point after someone's passed, and then through that estate administration, use it to transfer one's wealth.
Got it. Okay, all right. Now we have a question from Jane. And Jane, thank you also for watching Life Ahead here.
Yep.
Here's what Jane wants to know, Bryan. She said, regarding power of attorney, does an attorney have to write it for it to be legal? Or can somebody do it themselves?
Yeah, someone can do it themselves. I'm hesitant to encourage you to do, so to answer your question in black and white, yes, you can do your own document. I can fix my own car. I have zero skill. I'm great with woodworking. I can do all that. I have no mechanical ability. So can I fix my car? Yes, I can. Should I be fixing my car? No. There are things that you want to be aware of in your power of attorney. We want, depending upon what you want to get accomplished. There's sometimes when we're talking about elder law and protecting assets, there's some language that we want in there to be able to permit the person that we appoint, our attorney in fact, to be able to do certain things to help protect our assets. So somebody that isn't doing this on a daily basis may not be aware of that. Springing, non-springing, durable, not durable. So yes, technically you could do it by yourself. I wouldn't necessarily encourage you to do that. I really would encourage you to seek out counsel and seek out guidance in preparing that.
That makes sense. And yep. I think we have another phone call here from Joyce, I believe it was. Let's take a look at Joyce's question for us this evening here. I think that's going to be on the prompter here in just a second. Yeah, Joyce, if both parents pass, are their children responsible for their debts?
So, in a word, no. You are not responsible for your parents' debts. And I will receive that question. The children come in sheepishly and say, gosh, Mom had a lot of credit card debt, or there was a big mortgage on the house, and the mortgage is bigger than the home is worth. I don't know that I want to be appointed to be that.
They probably feel guilty, but they need an answer.
They need an answer.
Yeah.
I don't know if I want to serve as personal representative. I don't know that I want to serve as that executor because I'm going to be stuck paying those bills. No. You do not have to pay your parents' debts. You're not anybody's debts. When you're serving as their personal representative, their executor, their trustee, you are not personally liable. The assets of the deceased are used to satisfy debts that are valid in the estate or valid in the trust. If there's a claim that's made saying, gosh, I'm owed money, the executor, the personal representative can say, I challenge that. I don't really think that money is owed. So they can challenge that if they don't believe the debt is to be paid. Is an appropriate debt to be paid. But to answer your question, no. If you're serving as personal representative executor, you do not have the duty to pay your parents' debts or whomever else's debts.
What about a spouse?
You do not have to pay your spouse's debts. The exception to that could be medical debts. There's something in Indiana where one spouse is responsible for the medical debts of another spouse.
Okay, all right, that makes sense. I hate that our half hour has gone already.
Very quickly, yeah.
I know, it always does, doesn't
Yeah,
it?
it's
And
great.
there were so many more questions I had, but Bryan will be back, and hopefully you'll keep watching us here on Life Ahead. We're here every Wednesday night at 7:30 right here in the studio. Different topics, different guests, and like I said, you know, Bryan, I'm sure will be back here to talk to all of you and give you some good legal advice. Meanwhile, I'm just asking you to stay safe and stay healthy and enjoy the rest of the weekend.
The preceding program on PBS Fort Wayne was made possible in part by
Nugen Law, specializing in estate planning and elder care law, emphasizing independence and quality of life. Serving Indiana, Ohio, Michigan, and Florida. More information at nugenlaw.com.